Good afternoon, everybody. This is Christina Previtt, and I am a divorce lawyer at New Jersey Divorce Solutions, a law firm dedicated to divorce and family law matters in the state of New Jersey. I am here today with bankruptcy attorney Karina Lucid. Say hi, Karina.
Hi everyone, and hi Christina. Thank you for inviting me.
Thank you so much for joining me today. Karina is the CEO and managing attorney of Lucid Law Debt Relief Attorneys in New Jersey. She's also the author of Bankruptcy, A Fresh Start. If you'd like to know more about Karina or her law firm, or you'd like to get a copy of her book, please go to karinalucidlaw.com, and we'll provide that information for you in the comments if you'd like to reach out to Karina. But the reason we're here today with Karina is to talk about the intersection between divorce and bankruptcy. As a divorce attorney, doing this for about 15 years now, we very often see issues arising in the context of a divorce regarding bankruptcy. Sometimes people find that when they're getting a divorce, the income that previously supported one household isn't enough to support two households. Sometimes there's debt. There could be credit card debt. There could be issues making the mortgage payments on the marital home, or any other number of issues concerning debt that plague couples that are getting a divorce. And as a divorce attorney, I'm not always equipped to answer some of the nuanced questions that come up regarding that issue. So Karina has been gracious enough to talk to me today and try to answer some of those more basic questions that people who are thinking about getting divorced or find themselves in this situation might have. So thank you again for doing that for us today, Karina. The first thing I'd like to ask is if you can just sort of tell us generally who's a good candidate for a bankruptcy.
So, it's interesting you ask that, because I think in some regards it's easier to tell you who's not a good candidate for bankruptcy. The reality is that when I find that somebody is presumptively a bad candidate and not qualified for bankruptcy at all is really when there are somebody who has an income level that is below the median income in their state or region for their household size, but also has assets with substantial equity. So, for example, if somebody is earning below the median in their for their household size in their region, and they have $100,000 in equity in their home, what happens is they can't file a Chapter 7 because there isn't enough protection there to save their house, and they would end up losing their house in the bankruptcy process. But then they also can't file a Chapter 13 because they don't have enough disposable monthly income to pay a sufficient distribution to creditors to cover what creditors would otherwise get if they filed a 7.
Okay, so why don't we back up a little bit, because I feel like I don't want the viewers' heads to explode. Having actually been a client in a setting where I had to consult with an attorney, I actually realized that as a client, when you're the person sitting in the client's chair, sometimes the lawyer is using language that you don't really understand. So I'm going to pretend like I'm the client right now asking you these questions, and I kind of am, because I don't know bankruptcy. So when you say Chapter 7, what does that mean? Because I have some vague idea what that means, but for viewers, what does that mean when you talk about Chapter 7?
Right. So in a bankruptcy context, there are several different kinds of bankruptcy. A Chapter 7 is the type of bankruptcy that gives you the greatest breadth of relief. Okay, so if you are a good qualified candidate for a Chapter 7, you will get rid of all of your debt and you will retain all of your assets. So
that would be the best one, right?
Yes, that's the best.
If there's a good bankruptcy, that would be the one.
It's I mean, they're all good in their own right, but it's the best case scenario. You're in and out of a Chapter 7 in 120 days, unless you have, problems with your case, creditors that are, really contesting your bankruptcy, something like that. But for the most part, you're in and out in 120 days. And you know, you get to
It
keep
actually
all this
sounds
stuff.
like a long time, but it sounds like to you that's not a long
It's 4 months.
Okay.
So it really isn't. It goes by really fast, and especially, I guess, compared to the alternatives, right? If you don't do anything, your creditors can chase you for 20 years or more. And you know, I mean,
That's
just
right.
they can wait 2 years before filing a complaint, and then once they get a judgment, they have 20 years to act on their judgment. If you decide to file a Chapter 13, which is another kind of bankruptcy relief that requires a reorganization or repayment plan, those will last 3 to 5 years.
So when someone files for a Chapter 13, they're not just wiping out their debt. They have to actually pay some of it, right?
Right.
Okay. So is that basically the difference between Chapter 7 and Chapter 13?
That is the most important difference, yes.
Okay. And then, so for people that are watching and are thinking that this might be an option for them, is there some rule of thumb or some guidance you can give them where they could decide if they might be a good candidate for a 7 or a 13? Or is it more complicated than that? Would they need to come and talk to you?
I always recommend an in-person meeting to discuss the individual's personal financial situation, because everybody's situation is different, and you know, you don't want to take the risk of relying on generalities. But that said, there are certain generalities that you can take into consideration before even deciding to come in for a meeting. You know, our consultations are free. Almost all bankruptcy attorneys do a free consultation, so there's no harm in sitting down for a half hour with a professional that can really help you analyze your situation. But again, certain guidelines, right? If you have a lot of unsecured debt, like credit card debt, medical debt, personal loans, old business debt that has been converted into a judgment, that's one kind of unsecured debt that we see a lot. That may be something that, you know, you can then take the next step and say, oh, okay, I have, you know, well over $20,000 of these kinds of general unsecured debts. And then you look at the other side. Are my other obligations, like my mortgage, my car payment, alimony, which also can't be forgiven in a Chapter 7 or a 13, it can't be forgiven, period.
So alimony and child support cannot be discharged in bankruptcy.
Correct.
Okay. That's important.
That's really important. And you know, so you take into consideration those factors, and you see, you know, am I going to get enough benefit from the process getting rid of the unsecured debt that is dischargeable, and be able to deal with the debt that I'm going to be left with that is not dischargeable. And we'll help you figure out, you know, once we drill down the details, if the answer is yes, and it's best for you to go forward with a Chapter 7.
So that being said, I know it's more complicated and I don't want to oversimplify anything, but do you generally have the feeling that unless you have a certain amount of debt, it doesn't really make sense to file bankruptcy? For instance, I've had clients say, well, I have $20,000 in credit card debt, and you know, that's probably relatively, that's not a lot. I've seen most clients have significantly more than that, but for some people that's a lot and they're very uncomfortable with that, and they're maybe a little worried how they're ever going to pay it. Do you have a general feeling about what is enough debt that bankruptcy might be warranted? You know, is 20,000 really a lot in the grand scheme of things? It's
actually 20,000 is my rule of thumb. Anybody with less than $20,000 of general unsecured debt, I will try to find other alternatives for them presumptively. That said, you know, there is on the odd occasion somebody who has, you know, maybe $16,000 or $17,000 in debt, but just really cannot tolerate it, and you know, will file for them. But 20,000 is my rule of thumb generally to even go forward with the discussion. And that said, you know, most people have substantially more than that, because when it becomes intolerable is really when people come to see me.
And when you say intolerable, is that typically people that are just having tremendous difficulty making the payments, or just not able to make the payments?
Yeah, it's a combination of factors. When it becomes intolerable for a person, I mean, first of all, it really depends on the person, right?
Yes.
But for the most part, it's not being able to pay it. It's having exhausted all of your resources in an effort to keep up with it. People transitioning into underemployment, situations where they're earning less than they used to, and they just get that feeling that they're drowning. They just are never. They feel like they're just never going to catch up, and that's when they come here. And that's why my book is A Bankruptcy, A Fresh Start, right? Because it's that breath of fresh air. It's when you can't breathe anymore and you need to be sort of resuscitated financially.
And what would you say, what typically happens with respect to, in a divorce context, it becomes very important if the people have a marital home together. I know oftentimes in my cases, people are worried about, well, do we have to continue to pay the mortgage? What's going to happen with that? Are we going to have to move out? Is it a foreclosure? So can you just shed a little bit of light on that?
Yeah, I mean, it sounds like that's an easy question, but again, that really depends on the couple, on their individual circumstances. I mean, if they want to keep the house, then regardless what kind of bankruptcy process or anything else that they qualify for, they have to keep paying that mortgage. If they are in a situation where they're not going to be able to maintain the marital residence and they each have to get a separate house or an apartment or whatever it is, and they just need time to transition out, then oftentimes the recommendation is, stop paying the mortgage, save up for your transition, and then either put it into a short sale or let it go to foreclosure. It really depends on what the couple's going to do.
Okay, so it sounds like there are a lot of nuances and it really depends. That's the typical lawyer answer that we joke about. It depends.
It depends.
It does depend. And then one final issue that I would like you to talk a little bit about, and I think that you do talk about this in your book, is the emotional aspect of filing for bankruptcy, because so many people feel a lot of shame and embarrassment about even having to think about filing for bankruptcy. And we try to discourage people from judging themselves in that way, because sometimes it's necessary. So can you just touch on that a little bit?
I always have this conversation with my clients, and it is covered in the book. I give a couple of, real world stories of clients that I've worked with. And, the reality is you have to look at yourself the way that the credit industry looks at you. And when your income to debt ratio is so out of whack that you are drowning financially, getting rid of the debt makes you look better, not worse. And once you accept that reality of the way that the modern credit and lending world works, you have to realize you are actually making yourself look better. So you have no reason to be ashamed, and you have no reason to be worried about it. And if you're worried about what the neighbors think or what, other people might, your boss or whatever, you have to realize also that this is not a process that you have to share with people on the street.
Yeah.
So you're doing what you need to do.
Is a bankruptcy public record?
Bankruptcy is public record, but the likelihood of somebody thinking of searching you up with the right terms to find out if you were in bankruptcy, they'd have to be a little bit off themselves. And in which case, why are you worried about their opinion?
Yeah. Right? Yes. Well, thank you so much, Karina, for shedding light. I know you were really just touching upon some of these issues, but I think that these are some of the more dominant questions that we get. And for anybody who's thinking about bankruptcy or thinking about a divorce, sometimes these issues go together. If there's anything that we can do for you in terms of answering any divorce questions, please contact New Jersey Divorce Solutions. And if there's anything that you need in terms of a bankruptcy, please, I encourage you to contact Karina Lucid. I've worked with her on many cases in the past few years, and I absolutely respect her judgment very much. I think she offers legal advice, but also is very compassionate in the way that she does that, which I think she demonstrated for us today. So I would encourage anyone to contact her as well.
Thanks so much.
With that, I hope that you all have a great afternoon, and I hope everyone has a great weekend. Thank you so much, Karina.
Have a wonderful day, everyone. Thanks, Christina. Have a great day.
You too.
Bye.